Good morning, everyone, and welcome to today's session. How do you successfully restructure your workforce for the new world? My name is James Mattson, and I'm a partner at Bartia Perry in the Workplace Law and Culture team. I would like to begin today by acknowledging and paying my respects to the Gadigal people of the Eora Nation, the traditional custodians of the land on which we are broadcasting today. I would like to pay my respects to their elders, past, present and emerging, and acknowledge all Aboriginal and Torres Strait Islanders joining us today, also paying my respect to your elders, past, present and emerging. Before we get started today, I'd like to go over a few items so you know how to participate in today's event. You'll have the opportunity to submit questions by typing your questions into the box found on the control panel. You may send questions at any time during the presentation. We will collect these and hopefully address them through the Q&A session at the end of today's presentation, or if not, we'll respond to them at a later time. Otherwise, thank you for joining us this morning. How do you restructure your workforce in the new world? You probably want to be in a position where you want to get back to business as usual. Business as usual may mean continually adapting and moving to the environment as it develops. And there's no doubt that the environment in which we're in at the moment is going to be dynamic and fluid. So I want to look at the topic of restructuring your workforce in a new world in a bit of a broader sense than what might ordinarily have been the case before COVID. I want to organise my talk today in 5 key sections. I want to begin by talking about, well, what is this new work world post-COVID-19, or at present when we're starting to get back to working in a way in which perhaps we are a bit more accustomed. I then want to talk about the concept of flexibility, work location. I also want to talk a little bit about benefits, because these are areas where there's going to be some form of restructure, not a restructure in a redundancy sense that is very common in employment law, but certainly some changes will be occurring. And I want to talk about what are some of the legal principles and dynamics that operate there. I then want to actually talk about restructuring, talk about actually implementing redundancies, changing significantly the way in which we work, the way in which we're organised, as well as things that need to take place to avoid unfair dismissal claims and be able to rely on the cessation of employment being a genuine redundancy. And then we'll conclude and sort of bring all of this together in some really simple tips on how to approach, how to think about restructuring in this modern world, in this modern environment. All right, so let's get cracking. I want to begin by setting the scene in terms of what are some of the key challenges employers are going to have post-COVID-19, or certainly as we move from last year into this year, and certainly into the second half of this year. There's going to be continued tension and issues to do with flexibility, the location of work and working hours, and differing expectations, both from the business and the employee side. And you may even have different expectations in different business units within your business. And that's going to be a continual challenge to be able to manage that, and to be able to manage it in a way that enables you to be dynamic and respond to circumstances as they adjust. I think what we are going to be seeing, and indeed we've probably already started to see it, is that the way in which we deliver work and clients' demands and needs are going to continue to evolve. It's going to evolve from the perspective of either wanting to get back to business as usual, or to be wanting to deal with you and your business in a new way, in an improved way. And I've got to say, I've visited a few clients recently, and I've already seen work underway and work completed at different premises where there's been some new workspaces, where there's been an introduction of different work areas, hot desking. But these are going to be challenges for businesses in terms of coming to grips with what is the new workspace, whether it's working from home, whether it's hot desking, or whether it's working in some hybrid manner. And that's going to need to be dealt with, including, managing reluctance or outright refusals to return to working in the office, to return to have to work in a shared workspace, and the anxieties that come with that. There will always be, and this goes way back even before COVID, there's always refusals, reluctance, anxiety, and indeed adjustment disorders from a workers' comp perspective from some workers in being required to work in new ways. So still doing the same job, but doing it in a new way and not being familiar with that and not wanting to do that. And that's going to be a challenge for businesses and human resources. There's going to be challenges in the need to perhaps redefine, adjust employment conditions and benefits to deal with the way in which business is occurring now or in the future compared to the way in which it was determined in the past, and we'll talk a bit about that. And then there's going to be a big area where work health and safety, there's going to be emerging risks in terms of work health and safety that are going to need to be addressed. And last year, business was doing a very good job in dealing with that in a very responsive manner. But now there's going to be a whole lot more thought going into that and lessons learned, and we'll touch some of that. But there is no doubt that there's many positives when it comes to working flexibly and working in this new way. Certainly, what has been seen and what's come through certainly in some of the literature to date is that employees are more productive for particular work, working at home rather than in the office. And what we are seeing is that there is also an increase in productivity for some employees because they are working more hours without that daily commute to and from the workplace. Employees are able to work elsewhere, and they are able to have a balance in terms of their life and do so from a remote location, provided the technology is there. So provided the technology there is that ability to get work done in a productive manner. Employers now and businesses are now grappling with the ability to perhaps reduce fixed costs by reducing floor space. I certainly have seen some of you doing that and commencing and embarking on that process already. With that comes the challenges that if you're reducing floor space and people aren't coming into the office as much, that you can't expect a luxury office if you're only going to come in 2 days a week. And that's where the issues with hot desking and managing that change will be quite important. But certainly there's savings on both sides of the ledgers, both employer and employee. And as I said before, there's that balancing of work life. But there are some negative impacts that we need to grapple with. Some of those negative impacts include the fact that people are working remotely, perhaps collaboration, innovation can be stifled unless managed well, and there's also safety risks. And certainly you may all have read in the paper a few months ago, but certainly be aware of that there was a recent workers' compensation matter in the Court of Appeal, which dealt with the issue of whether or not a risk of domestic violence working from home was a foreseeable risk associated with home-based work. And the Court of Appeal to the question of whether injuries sustained working from home could be considered to have occurred in the course of employment when it arises in a domestic violence circumstance. And the Court of Appeal said yes, it can have that connection to work and be occurring in the course of employment. So safety, when it's not your domain, is something that needs to be thought about quite carefully. And indeed, upskilling managers to be able to deal with that is quite important. No doubt there's going to be some increased costs in technology, and indeed I suspect there's going to be demands made by workers for an allowance or for some sort of payment for their technology and equipment that they have at home to be able to work in this new way. And certainly that issue has popped up late last year before the Fair Work Commission, where a worker resigned, threw in the towel, because the employer said, I'm not buying you a desk. And the worker said, well, you know, I'm working from home, you've got to buy me a desk. And what the Fair Work Commission said was that it doesn't, that the requirement on employers don't require them to buy or provide furniture as a matter of course. And that the employee actually wasn't forced to resign because the employer said, I'm not buying you a desk. The simple fact the employee had a choice rather than resign, go out and buy a desk. But certainly we can expect those demands to be occurring. We're going to need to grapple with things such as trust, surveillance, how do we measure productivity, and we're going to have to deal with the risk of disruption and disputation that arises. So there's certainly some challenges when it comes to dealing with the modern workforce moving forward. Now, I'm operating today and I'm talking today on the premise that certainly we will be looking at, as businesses, as employers, on changing things. And we're going to be looking at adapting and changing the way in which we work, perhaps what we do, to meet the current business environment and remain a successful business. Now, whenever you make a change, you don't need to call it a restructure. It doesn't need to be a reorganisation. And I want to be able to put what a restructure in the employment law context is in perspective compared to the ordinary ability of employers to just change things. So let's begin by talking about flexibility. The employment contract as a device, it actually is flexible. It is adaptable, particularly when it comes to the performance of duties. And you can make changes, and that's okay because it's all part of issuing a lawful and reasonable direction. So there have certainly been cases where it's been said it's okay to ask someone to do something that's not in a position description. You know, it's okay to ask a senior academic to teach a class. It will be okay to ask a chief executive to look after a general manager's role for a period of time during an absence. It's okay to ask a very senior lawyer to go and do some research. Employment and roles naturally evolve and don't remain static. So if the changes you are making as part of reorganising your business are simply an evolution in the employment, an evolution in how work is done, as opposed to fundamentally changing someone's role, you probably have the flexibility to do that. And what I would encourage you to do is actually have a look at your employment contract and see whether you've got an express provision that allows that flexibility. Most do. If you don't, perhaps a good idea moving forward to perhaps insert a flexibility clause in the contract to make it clear that employees will be flexible to help you meet business and client needs. But there's always a caveat. You can't fundamentally or unilaterally change the contract without agreement. So you can't say, CEO, we no longer need you, we actually just need a cleaner. So you can't make such a fundamental change, and certainly those fundamental changes can be what's called a demotion. In that regard, I just quickly bring to your attention the fact that the Fair Work Act defines that a dismissal can include a demotion. That, though, is unless the demotion doesn't involve a significant reduction in remuneration or duties. So a reduction in remuneration will be a process you need to go through to do that, and I'll come to that in due course. But certainly right there, there's a recognition that, you know, duties can change. Now, one of the key issues going forward is going to be the issue of location. Can an employer change the location of where an employee works? And that might certainly be a real issue coming up in terms of, for example, you may want your roaming sales force to perhaps come into the office a bit more because there's a trend where clients aren't requiring site visits as much. Or there might be a need to move location because you don't need that big office space anymore. The short answer is yes, you can change location, you can change where work is to occur, but there are some limitations in that regard. Certainly earlier this year, the New South Wales Court of Appeal actually looked at the issue of being able to change location of work, and what the employee in that case relied on is the fact that, hey, my letter of offer that I've got says I'm employed to work at location X, and now you want me to go to location B, and I don't want to go there and you can't do that. And the court looked at the letter of offer and said, look, it's really not restricting the ability to move you, it's just saying this is where you are at the start. And in a real common sense approach, the court said, the mere fact that a letter says this is where your workplace is at the start of your employment doesn't deprive the employer the flexibility to make lawful and reasonable directions that someone relocate. And that's really what it does come down to. Absent location being an explicit and express essential term of the contract, an employer can issue a lawful and reasonable direction to work somewhere else, to relocate. Now, there's a mixed bag of decisions in that regard, so I can't say to you a hard and fast rule if it means more than an hour's travel, it's not lawful and reasonable, less than an hour, it is. It really depends on a range of factors, not just the travelling distance and the time, but also the costs, the impact on the employee and the personal circumstances, and outcomes can vary. Certainly, there was a case in 2018 where an employee had to move from the city all the way up to Eastern Creek. And that was considered to be a fair relocation, despite the worker having childcare responsibilities, no second car, and it meant an extra 3 hours on transport, on public transport for the employee. And that was found to be fair because the Commission took the view that the consultation process, the notice process that occurred, the employee had time to get a car. There were other options to travel out there that didn't involve that excess travel. Whereas 2019, different case, it was found to be unreasonable to relocate a bank teller who had grandchildren caring responsibilities to a location that involved an extra 70 minutes travel each day. Might be difficult to certainly reconcile those two cases, but certainly the factors that are considered tend to be the same: travelling distance, time, cost, impact on employee, and also what the employer offers by way of compensation or adjustment to enable that relocation tends to be important. But certainly that's something that you need to keep in mind in terms of making changes. So let's go to the absolute chestnut, which I think certainly we're probably all grappling with or will be grappling with, is the return to the office. Can employers demand a return to the office by workers? Certainly part of the issue will be, well, what was the original contractual commitment? What was the original understanding of the contract, which was probably that you work in the office, that you attend the office with the ability probably for flexibility in the ordinary course, as opposed to working from home being the absolute only circumstance permitted. Certainly, we've got to remember that a workplace is a place where we all come to work, to collaborate, to achieve common objectives. But there will be a challenge as to whether or not a workplace is a place where work is performed. And there probably is a fundamental difference in both views. I think the law will come down the side of, if an employer addresses safety in the workplace from COVID-19, then it's likely to be a lawful and reasonable direction to require people to return to the office, though there is always going to be the need, as there was before, a need to assess any requests that are made for seeking flexibility, particularly if there are those carers' responsibilities or other personal circumstances that justify some accommodation. And that's going to be something that is needed to be dealt with in the ordinary course. Now, something that I do want to spend a little bit of time talking about, because this is something that is arising, is how do we deal with changing benefits? It may be, and this is certainly a drastic illustration, but it may be in theory that you agree to, with an employee, a very attractive sales commission structure for selling a particular product. It's new, it's novel, and it's going to be really hard to get sales occurring. But if that benefit changes in the way in which it's valued, because let's say the product takes off, let's say the product becomes much easier to sell perhaps online, and as a result the employee gets a windfall that was never intended, can you change the arrangement that is in place? Can you say, well, we need to update your benefits in this regard? Now, a lot is also going to depend upon what are the contractual terms that were agreed, but we always start from the premise that an employer can't unilaterally vary essential contractual terms when it comes to matters relating to pay. And if you did do that, if you did unilaterally say, oh, well, we're not going to pay you a sales commission anymore, or we're going to reduce your salary, an employee would then be able to perhaps bring the contract to an end, lose the benefit of restraints could be a consequence of that, and/or they can seek damages as a result of that unilateral change. And certainly any change that you seek to make needs to be agreed, and any change needs to occur as part of an offer and acceptance process. So, for example, if you needed to make a change, you might require any change, for example, in a commission or sales incentive plan, assuming you don't have the contractual ability to change it, as being a condition to getting a pay increase. So you might say, look, good performance, we're going to give you $5,000 extra this year, but it's on the condition that this is the new incentive structure. If not, we're not giving you the pay increase. So that's certainly one way you can deal with it. But when it certainly comes to dealing with schemes, you've got to really look at the contractual terms. A good incentive or commission scheme will try to be separate from the contract, will try to be updated every year. And then that can certainly give you the ability to make changes there. But we do need to keep in mind that these schemes will often talk about a discretion, or a sole discretion or absolute discretion of the company. Any discretion would need to be exercised in a good faith way, not exercised in a way that is arbitrary or capricious. You've got to have regard to, well, what's the contractual purpose of this incentive scheme? It's to reward performance, and if the performance is being achieved, you just couldn't say, well, you're getting nothing because it's my discretion. You'd need really good business case, such as dire financial circumstances or some other compelling reason to act in that manner. But certainly moving forward, I think all businesses need to start thinking about, well, how are our benefits set up? how do we need to best place ourselves to be able to adapt the way in which we reward, particularly if the way in which we're going to work is going to change, because ultimately these schemes are about being rewarded for effort made. But if the product, for example, if the reward is you get X% of all products sold in the business, but your IT department has built a fantastic website and they're just all selling themselves on the web, you might really want to change that incentive scheme because it's linked to the employee's particular reward. So that's certainly something that needs to come about. So in terms of making those changes, there's a few key tips that I think are important in terms of managing that change and how to go about doing it. And doing it in a way in which perhaps you're not talking about, well, there's a restructure or a reorganisation, because certainly what we see when that happens is immediately employees are talking about, well, I want a redundancy. Where's my redundancy? And as the Fair Work Commissioner said in a number of decisions, redundancy is not an entitlement when there's still a job. Redundancy is not something that employees should get when they have work, when they have acceptable alternative employment available to them. The whole scheme of redundancy was set up to keep people in work. It's only when there is no other work that those entitlements kick in. So I think in terms of getting ready to make that change, I think it's very important from a business perspective, and this will come out a little bit later in my talk in terms of some of the cases we're going to go through, but you do need to develop a very clear and good rational business case for the change that's occurring. That's going to be very important in terms of managing the change. Certainly, there are a number of anti-bullying cases at present that have gone through the Commission where change has been implemented by the business. An employee has been resistant to that change, and there are a small percentage of employees that are always going to be resistant because they just can't handle the change, they can't process it, they can't manage it. And where they then see management saying, well, you've got to do it this way, and performance managing them turn around and say, well, this is bullying. This is bullying of me, and bringing a claim. And those claims are successfully defeated when there is that good business case for the change, and it makes legitimate, intelligent sense, but also when there is this engagement in a dialogue before implementing the change. One of the key things I think business is really good at is planning change, and managers sitting around and talking about the ins and outs, the pros and cons, but the employee isn't there. So the employee isn't aware of what's happening. They don't have time to get their head around it. So engaging in that dialogue is important to bring them along for the journey. Certainly, you've got to consult, you've got to seek input in that regard, and we'll return to that in due course. Certainly, when it comes to, for example, wanting to redefine the way in which work's done, change duties, or even possibly change benefits, evidence that you've considered what they've said in response, evidence that you're, just check if I'm still here. Yep. Evidence that you've thought about. I just do a quick check. My screen's flickering here. Apologies. Okay, so I think I've fixed that up. Okay, apologies, everyone. As I was saying, evidence that shows that you're engaged in this dialogue, you've considered concerns, and indeed that you've even made some modifications to your arrangements, certainly all within the terms of the contract and the purpose of it, will be quite important to perhaps even demonstrating that the changes made aren't that big restructure that give rise to an entitlement to redundancy, but part of the normal evolution. And I think key is also to give notice of the change. So after you've had those discussions, certainly make it clear that, okay, well, we're intending to now implement this from 1 July. So that way that person has notice. Now, sometimes I spoke before about, certainly if you're going to make a change, for example, in commissions or benefits, you might certainly do it conditional on getting a pay increase. Equally, if the changes do need to be made, you might want to even take the approach, and this is certainly a robust approach, but you may certainly say, well, we give you notice that we're ending the current contract, but here's a new contract, and it's up to you whether you accept it, but if you don't, then you leave the organisation. Now, that's certainly a robust way in which to achieve change, not necessarily a favoured approach, but certainly it is available in some cases of actually just ending the existing arrangement, ending the existing employment, but offering the same employment on different terms. And that remains a legitimate way in which to manage the situation, and certainly a lot easier to do for those employees that are more senior and outside of the unfair dismissal regime. So I can't have a talk about restructuring the workforce without talking about redundancy and without talking about the important processes that need to occur in that regard. Certainly, ending employment by reason of redundancy under a contract requires you to give termination on notice, and certainly if redundancy or there is a severance pay condition in the contract, well, then you'd need to comply with that. We also need to be aware of, and this sort of supports the fact that you engage in dialogue as early as possible, that for some employees, if there's no written contract or no express contractual term dealing with termination, you might need to give reasonable notice. Certainly, I think the law is suggesting that certainly if notice is a part of an industrial instrument, then reasonable notice won't be implied, but we just need to be aware of that. You need to be thinking about what are the employee's contractual terms if you're going to end their employment. And certainly under the national employment standards, there's obligations to pay redundancy pay if the employment is terminated because, I emphasise that, because the employer no longer requires the job to be done by anyone. And there are some exemptions in the case, for example, of a transfer of employment. So if part of the restructure is to move a person doing the particular job, but it needs to be done in a related entity, there may be very well no entitlement in that case because there's a transfer of employment, and there is the ability, if an employer obtains other acceptable employment for an employee, to apply to the Fair Work Commission to get a reduction to redundancy pay from nil. But I do want to emphasise the point that redundancy pay under the national employment standards arises if the employment is terminated because the job is no longer required to be done. So certainly I've had a few cases where the business has made the decision to end a person's employment because they're no good in the job. And for whatever reason, they've decided not to end that person's employment immediately because they're in a key role and better to be doing something than nothing. And they look for a replacement and find a good replacement, and you then define that role for that person, and you end up bringing the other person's employment to an end, and they see that the new person who's taken over has a different job title, and they allege, hold on, I've been made redundant, where's my redundancy pay? That person's employment was ended because they were a poor performer. Therefore, they're not entitled to redundancy pay. And that's certainly a very important point to note. There are issues, though, if you're getting rid of someone due to performance and they're within the unfair dismissal jurisdiction, then you won't be able to have access to the get out of jail card from the unfair dismissal laws, which is someone cannot bring an unfair dismissal claim if their employment ends by reason of genuine redundancy. So it is important to be clear why you're getting rid of a person. Is it because their role's genuinely no longer required, or are you actually getting rid of them for other reasons, in which case that needs to be your reason, and that then defines what the entitlements are, and it also defines what claims or causes of action they have. So let's talk about what's a genuine redundancy, defined in the legislation. Really, there's three key elements to what is a genuine redundancy. Firstly, the job is no longer required to be performed by anyone. Now, that has to be because of operational requirements in the business. And that's an important point that can sometimes be forgotten when we just say job no longer required to be performed. You will often hear me, if we're having a chat, about asking, okay, why has this change come about? What's the change in the business? What are you trying to achieve operationally? And that's because the person's job is no longer required to be performed because of operational requirements. The second element of a general redundancy is there needs to be consultation. And the third element is that you've got to look at redeployment, and if it is reasonable to redeploy someone, that you then do so. If those three elements are satisfied, it's a genuine redundancy, no unfair dismissal claim can be brought. So let's dive a little bit into those three elements. First of all, it's important to note that a job involves a collection of functions, duties, and responsibilities that are given to a particular employee. That's quite important, because the question is whether the job is no longer required, not necessarily the duties. So the fact that some duties remain, or the fact that all duties remain, does not of itself then mean that it's not a genuine redundancy. Simple example is you have 6 sales staff, but because of financial pressures, you need to only have 4, even though the sales work is still occurring. The reassignment of the work really does mean that part of an operational change, 2 jobs are no longer required. And that is really the question. After the change, after the reorganisation, are there any duties left for the employee to be discharged? And if there are none to be discharged, then, and that can be either because the duties are eliminated or they're given to other employees or they're outsourced, then a job will no longer be required in that relevant sense. Now, extreme cases illustrate good points of law. So I actually want to talk about this case, which is a case from last year. Great drama in this case. Father and son, both directors of a company, and they engage a national sales manager who also happens to be a long-time family friend of theirs to help them grow the business. Meanwhile, the father gets remarried, and his new wife does not like the national sales manager. She accuses the national sales manager of getting up to things with her husband. The father later on approaches the sales manager and says, I'm going to have to let go of you. Otherwise, his wife's going to leave him. So he made a call. He made a call. The sales manager then received a letter that said, your job's made redundant as the company is facing financial difficulties, and he sued for unfair dismissal. And at the hearing, the respondent said, well, here's the profit and loss statement, and actually we are in financial difficulties, and this is a genuine redundancy. So that's the issue. They're the facts. Perhaps it won't surprise you that the Commission was very clear that the job needs to be no longer required to be performed because of changes in operational reasons. And there may have been no doubt here that a restructure would have needed to have occurred to improve the financial position of the company. But unfortunately, the evidence was that it all came about because the father was trying to save his souring marriage, and he needed to meet a demand, and that meant the job was lost. Sure, there may have needed to have been a restructure at some point, but what drove this termination of employment was not operational requirements. It was because the wife wanted him out of the business. Now that's really an extreme case, but an important point, because often in discussions I will have, people will say, oh, they're not a good performer. They're not meeting the targets. It's not working. Can we make them redundant? And therein lies a risk. Therein lies a risk that the reason for termination is not operational requirements, but rather the person's performance. Now, it's also not uncommon for the discussion to go along the lines of, we need to look after this client, we need to service them in better ways, I'm thinking of making these changes. Oh, and by the way, this person's not the best performer. Sometimes poor performance identifies problems in systems and processes. Sometimes poor performance identifies opportunities for the business to better structure itself. A deeper analysis always needs to occur to be assured that what is really motivating the dismissal is a change from operational requirements as opposed to performance. Because if you don't get over this hurdle, then the failure to deal with performance, the failure to manage performance will then be found to be unfair because you've completely avoided it by just going down the wrong route of redundancy. Now, it also doesn't mean that the fact that even if you are performance managing someone, that their role can't be made redundant, but you would need those operational reasons to back that up. Consultation, very important, not only because it's very likely to be an obligation in an award or an enterprise agreement that might apply, but it's important that the obligation arises, and this links back to what we were talking about earlier, that it arises when a definite decision to make major changes that are likely to have significant effects on the employees occurs. So certainly if you're going to make some changes and they're not going to have significant effects, then the obligation to consult doesn't legally arise under the industrial instrument. It might certainly be something you do for many other reasons that I discussed earlier. Consultation is quite important. It involves three key elements. It involves giving notice of the decision. It involves providing in writing relevant information, so that way the employee can discuss with you the effects and measures to avoid or reduce what could be an adverse situation for them. And certainly the Commission has described on a number of occasions the fact that consultation isn't this tick the box exercise. Consultation is got to be a genuine process where you exchange ideas, but also It's a humane way in which to take account of employees' views, and certainly even from a workers' comp perspective, and I think it's fair to say that you will see an increase in claims if you go about a restructure in a way that occurs in an unreasonable manner. You might not get exemptions under workers' compensation legislation to avoid having to pay compensation to someone who suffers a psychological injury as a result of a very poorly managed process. And that then can certainly have premium impacts. There's this case which is worth mentioning quickly. It involved a labour hire arrangement. It's not uncommon in many industries to engage in use of labour hire. The client saw a drop in production, therefore wanted to reduce its workforce, and it no longer needed as many drivers as it had. A labour hire company telephoned one of the employees, said there's no longer any work there, and then they weren't assigned any further duties and just told to wait until they were redeployed. That didn't occur, and instead their employment was ended, and then an unfair dismissal claim was brought, and there was an argument that it was a genuine redundancy. Unsurprisingly, the Commission focused on the fact that there was this obligation of consultation, and there was simply no evidence of that occurring. What there was evidence of was putting someone on the sideline and then saying, well, we've got nothing for you, you're redundant. And it's an important obligation. It can't be ignored. It needs to occur. Certainly, you need time for that to occur. Certainly, a common question we get asked is, how quickly can I end the employee's employment for redundancy? Can I talk to them today and make my decision tomorrow? This consultation obligation needs to be genuine. It needs to follow a process, and that will involve, a few days to maybe a week if you're going to do it genuinely. And you need to do it genuinely because you've got a serious obligation when it comes to looking for redeployment opportunities. You've got to make an assessment as to the skills and capability of the person to perform the role, or to be able to perform the role, and by the role I'm talking about an available vacant role in the business, with appropriate support. So it may be that a person might not today have the ability to do the job, but with a month's training, they can do the job. And part of the obligation of reasonable redeployment is to look at that. You've got to look at lower roles, including if there's less income and responsibility, and look at redeploying them into that role. And redeploying is about redeploying. It's not about making them compete for a vacant role. Now, there may be some applications and competition for a vacant role. For example, if you've got 3 people redundant and only 1 position to redeploy. Absolutely, in that case, you can have a competitive process, but it will be between those 3. You wouldn't say, oh, well, now we're going to open it up to the market, particularly if you have assessed that people have the skills and the capability to do so. Only because of the times we're in, I raised this recent case where there was a restructure of the workforce for very legitimate operational reasons, and one of the employees wanted to remain employed, and they were offered the opportunity to apply for a newly created role. There was an interview process, and during that process, they expressed views. This was a religious organisation, expressed views which were viewed as progressive and not conservative, that reflect the organisation. And as a result, they thought this candidate wouldn't be suitable for the role. The issue that then arose was, has there been a genuine redundancy? And in that regard, what they were looking at would it have been reasonable to redeploy the employee into that role? And whether someone has progressive or conservative views or views different to the organisation, the issue ultimately is, do they have the skills to do the job? And will they really, or is there any evidence to really suggest that those views would actually have an impact on their ability to do their job? And in this case, there was no evidence that the employee could not do their job or the inherent requirements of the job, regardless of what their views were. And as a result, the Commission said, as they've said on many occasions, this worker should have been redeployed into this role rather than to have to compete with external candidates, because it is the obligation to redeploy that arises first and foremost, and that is the obligation that needs to be satisfied. What they don't look like and what is not looked at in the unfair dismissal process is the selection process that occurs. So certainly in unfair dismissal, they won't look at whether you're applying the last on, first off principle, or whether your selection criteria on which you decide on merit was fair or not. But you do need to be aware that that process or that principle of last on, first off could be discriminatory, and there is always the ability to challenge a redundancy on unlawful grounds. But outside of it being unlawful, at the end, it's the employer's decision as to how it arranges its affairs and conducts its business, provided it goes through the processes spoken about. So let me conclude by just talking about some tips. I think, firstly, a key tip that I recommend is explore existing flexibility before calling it or embarking upon a restructure. The use of that word can tend to obscure what might be occurring, which is something lawful and normal. Certainly where the changes are more significant, that consultation and discussion might also get their agreement rather than relying on a lawful and reasonable direction, which then raises issues of disobedience and is a rather combative approach. Plan very carefully how the new roles in the organisational structure will look and have a really good business case. That's important to be able to defend the operational reasons link, but it's also important about being clear in terms of what's occurring and how it's being managed through the processes we've discussed. Never forget to bring an employee on the journey. Consultation is vital, and be prepared to listen to the feedback and be prepared to tinker with your proposal. That's always good evidence that you followed a fair process, that the process is not unlawful, not motivated by complaints that may have been made and the like. And it's also important to be able to fight off what might occur, which is those anti-bullying applications and indeed workers' comp claims. Finally, or second last, I think, look at available roles and the benefits for redeployment. And that also gets in the ability for you to, if there's a refusal to take that role, to perhaps avoid paying redundancy entitlements. Certainly someone doesn't have any entitlement to redundancy if there is acceptable employment elsewhere. And if you have time and you can afford some notice and transition, take advantage of that luxury. Time, or the lack thereof, often when we look back in these matters, is your worst enemy, a lack of time. So if you've got time to plan this, you've got time to engage in all the processes that I've mentioned, that's going to make things a lot easier. So let's just see if there's any questions. Feel free to send them through. We've got a little bit of time. Have I hit the right button? Yep. Otherwise, if you're all happy to get your day started, I hope you have a lovely day. All right, so there doesn't appear to be any questions at this stage. Have a lovely day, everyone. Glad you could join us. Stay safe. Bye.